Good afternoon. Because I don't sneeze. Good afternoon, chat. Welcome to the show. We got a little bit to talk to. We got some Supreme Court stuff to get into today, and it's a pretty interesting one. It's a pretty interesting one for the Supreme Court. It's about the idea of discrimination. More importantly, workplace discrimination. Why am I echoing? All right, there we go. That's better. What we're talking about today is the issue of reverse discrimination. Now, you might say, well, wait, isn't it just discrimination? Yes, it should be considered that way, but for a long time it wasn't. When you were discriminated against and you were in the majority group in a majority employer, the rules were different for a very long time. For a very, 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 very long time. All right. So if you're the member of a majority group, you couldn't just say, hey, this is discrimination and that's it, and file a lawsuit. There were things you had to do in addition to it. And one of the things you had to show were background circumstances that supported the suspicion. The employer is what they called an unusual employer who discriminates against the majority at that business. And where does this come up at? Well, it comes up in a lot of places, but it's Title VII. And Title VII is the federal law. It's part of the Civil Rights Act. And it prohibits employment discrimination based on race, color, religion, sex, and national origin. And it applies to companies that have more than 15 people. But it also includes state and local governments as well. So they are also prohibited by this from discriminating against people. And as we get too far, guys, welcome to the show. My name's Sean, also known as Potentially Criminal. I'm an attorney in Ohio, and we're going to get into this issue of discrimination today. So the Civil Rights Act prohibited all those things. Okay, great. But let's say you're a white person, and it's a majority white business, and the majority of the employees are white, and you're in the majority, clearly, and you feel you're being discriminated against. What do? Well, you do bring forth an employment discrimination claim, and you do that. And then there is a case that sets forth this. When you're alleging discrimination under Title VII, and this is, I remember going through this through my employment law class I took in law school. You have to do what's called the McDonnell-Douglas Corporation, the McDonnell-Douglas burden shifting test. Okay? You can call it a framework, but it's a test. If you allege discrimination, you initially prove it. You initially allege it. And how does it work? You must establish a prima facie case that you're being discriminated against to survive summary judgment. Okay. But your employer, also the defendant, they then get to rebut that. And they can rebut that by producing evidence of a non-discriminatory reason for its actions. So they can bring up reasons of whatever they want, as long as it's reasonable and it's non-discriminatory. If that's the case, the presumption of discrimination dissipates. And then at that point, if you are the plaintiff, you have one last thing you have to do to keep moving forward. You are given one last shot. You must show that either the explanation is insufficient, it's a pretext for the discrimination, or by otherwise proving the actions used one of the unlawful discriminatory parameters. So you initially make your claim. The defendant can rebut it by saying, look, we have a non-discriminatory reason. You can challenge that reason at times. You can challenge that reason. But it's a tough road to hoe. And then if you are in a majority group, you have a fourth factor. There's a fourth factor attached, and you have to show the background circumstances. You have to show the background circumstances at that point. and that they are the unusual employer who discriminates against the majority. You have to show that they're being real sus. You have to show more than anybody else does. You're thinking, wow, that seems pretty unfair. Well, it's been thought of that way for a long time, but since 1964, that's been the standard. Now we move on to the case of Ames versus the Ohio Department of Youth Services. So the Ohio Department of Youth Services is also known as DYS. They are basically the prison system for juveniles. They do a lot of things for kids. And what happened here? So a lady named Marlene Ames is a straight woman, and she worked at the Ohio Department of Youth Services. And she had worked there since 2004. In like 2017, 2018, she had been reassigned to a supervisor who was a lesbian. And later on in 2019, she applied for a promotion. Her application was rejected, and she got not only was her application rejected, she got demoted from her position. The promotion was given to another lesbian, and then her position was given to a brand new guy they hired who was gay. So you're like, how does that work? How does that work? Well, at that point, she went to court and she sued and said, I've been discriminated against because I'm not gay. Well, the district court, said, I'm sorry, it doesn't work like that. They said, sorry, summary judgment's granted. You haven't shown the background circumstances. You haven't shown that the minority group made that decision against you. She went to the Sixth Circuit. And the Sixth Circuit, interestingly enough, said, look, we have to uphold the lower court's ruling, but we agree the Supreme Court really needs to look at this and fix this problem. Because discrimination is discrimination. Is discrimination. There shouldn't be a separate standard. Remember, separate but equal is not acceptable, except for here. So she got certiorari, and the Supreme Court rendered its opinion, and holy cow, its opinion was pretty impressive. Because how far did they get in this? Well, it's a 9-0 case. And it's a 9-0 case. And things are bad when Justice Ketanji Brown Jackson is the one delivering the opinion of the court. Like, that's how you know how bad it is. That's how you know how bad it is. So this is the case. And this was decided June 5th. So this is pretty new, guys. This just came out. It came out in the midst of Karen Reed, so we didn't have a chance to get to it. But, here we are. We're getting to it now. Justice Jackson delivered the opinion of the court. And what happened here? Well, Jackson delivered it. Thomas filed a concurring opinion, and Gorsuch joined the concurrence. So it's a 9-0. It was 9-0. It was per curiam. So what did she start off with? Well, they start off with the basic information. And they start talking about Title VII. And it prohibits employers from... Oh, we should zoom in a little bit. It prohibits employers from discriminating on the basis of race, color, religion, sex, and national origin. Under Title VII precedents, a plaintiff must make out a prima facie case of disparate treatment. And disparate treatment is one of the things you can show for discrimination. There's disparate treatment, and there's disparate impact. There's two different kinds. So, disparate impact is a theory that, you're liable for discrimination even if it's a neutral policy. On its face, you made a policy. I wasn't trying to discriminate. I tried to make one that worked for everybody. I have no racist bone in my body. Our company made the best decision it could. It still impacts a protected group in a discriminatory manner. That's it. That's a bad problem. It's still bad. Is it the worst thing? No. Disparate treatment is the worst kind. Now, disparate treatment obviously is what it sounds like. You are intentionally treating someone poorly. You singled them out, you made them less favorable, you singled out a group, you made it less favorable, and you were motivated by discriminatory intent. So yes, if you were going to be doing one or the other, it's always better to have a disparate impact. But either way, a company could be doing everything right or think they're doing everything right. And if a court determines and the EEOC determine, no, you're being discriminatory, your ass is grass. So I know people have heard those terms before. They are separate terms. But she did file a case of disparate treatment. She believes she was singled out, which is the worst kind of discrimination. So she applied for an available position which she was qualified, and she was, but was rejected under circumstances that give rise to an inference of unlawful discrimination. And the question is whether to satisfy that. If she's a member of a majority group, must she also show the background circumstances to support the defendant is that unusual employer who discriminates? We hold this as not consistent with Title VII's text or a case law construing the statute. So we're going to get rid of it. And we're just going to use the first three factors. We're not going to make her do an extra one. It's not fair. So she talks about what happened here, and she says, ultimately, she was an executive secretary. She was eventually moved to program administrator, and she applied for a newly created management position. Although the agencies interviewed her for the position, it ultimately hired a different candidate, a lesbian, to fill the role. After she interviewed, her supervisors removed her from her role as an administrator. She accepted the demotion where she had first joined the agency, and it resulted in a big pay cut. The agency hired a gay guy to fill the vacant program administrator position, and she sued. District Court granted summary judgment, and they used the McDonnell Douglas Corporation versus Green framework. The Sixth Circuit affirmed. So the court reasoned that as a straight woman, she was required to make the showing of, in addition to the usual ones for establishing. And they say they could show this by presenting evidence that a member of the relevant minority group made the employment decision, or with statistical evidence showing a pattern of discrimination against members of the majority. So remember, that's how you show that unusual circumstances. Remember, you have to show that. You have to show this thing, this background circumstances. This is unusual because I'm in the majority, and you can use statistics. You can use information. You could say, look, she could say, look, the homos made the decision. Well, there you go. Judge Kethledge, and he was actually one of the people before Brett Kavanaugh got picked for the Supreme Court. This was one of the people in the front running for things, was this Judge Kethledge. I don't think he is anymore, but at that point in time, he was. So that is, he is, how old is the guy right now? He is 58. So yeah, he's not really probably he's not a spring chicken anymore. So he is, he is the guy who is probably going to take over if Kavanaugh didn't go through. So he concurred with the decision, but wrote to express his disagreement with the rule. And he's like, look, this is bullshit. In his view, the requirement was not only unworkable, but it required an assessment of evidence presented by different plaintiffs under different standards, which we're not supposed to do that. Wait, that's separate but equal, isn't it? Kind of, yeah, a little bit. So the Sixth Circuit's decision reinforced a circuit split as to whether majority group plaintiffs are subject to a different evidentiary burden than minority groups under McDonnell Douglas's first step. And they say they granted certiorari, and they point out because in addition to the Sixth Circuit, 4 other circuits have held or suggested that majority group plaintiffs must satisfy a heightened burden to make out a prima facie case under Title VII. So not only that, but it's the 8th Circuit. And we'll go down through here. I mean, it's a pretty big split. You've got the 7th Circuit, you've got the DC Circuit, and you got the 10th Circuit. The other circuits do not pose any heightened burden on majority group plaintiffs. So they point out that this bars employers from discriminating against their employees based on race, religion, color, sex, or national origin. And the court lays out its 3-step framework. The first step of the 3-step inquiry, the plaintiff bears the initial burden of establishing the prima facie case by producing enough evidence to support an inference of discriminatory motive. If the plaintiff clears that hurdle, as I said, it's like tennis. It now goes to the employer to articulate a non-discriminatory reason for the employee's rejection. And then finally, if they do that, the plaintiff has a chance to show the stated justification was just a pretext for discrimination. You can succeed either directly by persuading the court that a discriminatory reason more likely motivated the employer, or indirectly by showing the proffered explanation is unworthy of credence. So you can just say, look, guys, it's bullshit, or you could say, look, it doesn't work. There are ways you could show it either way. And they say for most plaintiffs, the first burden, the first step, is not onerous. You may satisfy it by simply presenting evidence you applied for an available position. But under 6th Circuit precedent, plaintiffs who are members of a majority group bear an additional burden at step 1. They must also establish the background circumstances to support the suspicion the defendant is that unusual employer who discriminates against the majority. And they say, as outlined below, the background circumstances cannot be squared with the text of Title VII. And nothing Ohio has said in its brief or an oral argument persuades us otherwise. So they say, as a textual matter, Title VII is about drawing no distinctions between majority and minority group plaintiffs. They say it's all about no discrimination at all. You can't discriminate anybody based on race, religion, sex, color, or national origin. It doesn't say minority or majority groups. Title VII just says all discrimination is bad. Because it covers any individual against any individual. The law focuses on individuals rather than groups as anything but academic. There's a reason why it talks about individuals. Congress left no room for courts to impose special requirements on majority plaintiffs alone. They're just saying this is discrimination. It doesn't matter who does it. Is it discrimination? Yes, it is therefore illegal. You are not allowed to do it. You are not allowed to do it. And it sounds like, really, this shouldn't be that hard. But courts have gummed up the works doing this. And organizations have destroyed, this is too hard to understand. Tuckek says, discrimination bad. How long did it take them to figure that out? Quite a while, apparently. Quite a while. Jefferson Post says, looks like white bread is back on the menu, chat. Well, actually, what this means is if you're a DEI hiring company, you better watch out. If you're a sweet baby in court, if you're like in the gaming industry, watch out. Watch out. There might be some employment lawsuits coming your way if you work in Silicon Valley. Or you're like in a very liberal establishment area. Be very careful. And then Sleazy for $20. Thank you, Sleazy. Says, if she be in the kitchen, none of this would have happened. Prove me wrong. Well, that's very true. That's very true. Thank you, Sleazy. Thank you, Jefferson. The big support tonight, guys, so far. Big support. The gaming industry is too cucked to do anything. I'm not worried about the gaming industry. I'm worried about the employees who lost jobs suing the gaming industry. This really hurts Hollywood. It's going to hurt everybody. They say our presence alone reinforced the understanding of the statute. And they talk about in 1971, we said that discriminatory preference for any group, minority, or majority is precisely, notice minority or majority, is precisely and only what Congress has prescribed in Title VII. They made the same point even more explicitly 7 years later. The employer in that case argued that certain forms of discrimination against white employees fell outside of Title VII. But they rejected that argument. And they said Title VII prohibited racial discrimination against white petitioners, in that case, upon the same standards as would be applicable were they Negroes. And yes, in 1976, they were still using the term Negroes in the court. Remember, a lot of those guys in the court at that point were boomers. Boomers. So. They just keep pointing out here. They say our case law makes it clear the standard does not vary based on whether or not you're a member of a majority group. They say the background circumstance rule flouts that basic principle. I mean, think about it, guys. This is just a complete. Normally, we've got to read through a bunch to get to the point. This one, the Supreme Court is coming out right out of the gate saying, look, this is simple. You can't do this. You've never been allowed to do this. We're not even changing our mind on something. We told you can't do this. We told you can't do this for over 60 years now, and you're still doing it. So this isn't even, they're not making anything up. They're literally saying, we've said you can't do this. You're not allowed to do this. They say this rule also ignores our instruction to avoid inflexible applications. This court has explained that the precise requirements of a prima facie case can vary depending on the context and were never intended to be rigid, mechanized, or ritualistic. They say in McDonnell Douglas itself, we observe the facts necessarily will vary in Title VII cases, and that prima facie proof required can therefore differ from case to case. And this rule uniformly subjects all majority group plaintiffs to the same highly specific evidentiary standard in every case. Which, remember, they said already it's case dependent. But this thing is here saying, nope, every case is the same. It's like, no. They point out this court has long rejected such inflexible formulas of prima facie standards in disparate treatment cases. And notice, they're already 1977. Once again, we're like, we're not doing that. And we'll do it again today. They point out Ohio barely contests any of the above. This is Justice Jackson just beating their ass at this point. At oral argument, the state repeatedly acknowledged that Title VII's disparate treatment provision imposes the same burdens that it imposes on minority plaintiffs. And they say its brief likewise offers no justification for imposing a heightened standard. Instead, Ohio tries to attack the premise of the question presented by arguing that the background rule does not operate to subject majority group plaintiffs to a heightened evidentiary standard at all, but it does. If you don't prove it, you're toast. Hold on, chat. Sorry, guys. Hold on, one more thing. All right, chat. Sorry. Hold on one second, chat. All right, chat. Sorry about that. We're back. No, nobody called. That was taking care of something else. So they go on to point out here that it's not an additional element, but just another way of asking whether the circumstances are otherwise explained. Now they point out though that that's what Ohio's trying to claim. Ohio's like, look, it's just another way of explaining it. But the Court of Appeals said no, it is a requirement, and which means she must make an additional showing of the establishment of a prima facie case. So remember, they're trying to say, oh look, it's still just part one, and no, the Court of Appeals is like, no, it's still a fourth extra part everybody has to do. So the court stated whether Ames made the necessary showing of background circumstances the principal issue, because otherwise her case was easy to make. Think about it. You've got a home run, knock dead, drag him out case. But now we're going to slap you with this extra burden that you can't meet. You know, they point out she was qualified. She had been denied promotion in favor of a gay candidate and was later demoted in favor of another gay candidate. Evidence that would ordinarily satisfy her burden before it specifically faulted for failing to make the requisite showing. So in short, they said, look, it should be fixed, but this case of background circumstances misses the mark by a mile. They also want the court. They also came up with a different argument here. I listened to the oral argument. The oral argument wasn't impressive. They got their ass kicked, but it wasn't really interesting. It was kind of boring. They say that it should fail anyway because even absent this, there were other alternatives and there were other options. And they say that these all fell apart. We grant a review to consider the validity of the background circumstances rule. And we reject that rule there. They said, we didn't touch any of your other arguments, so you're free to make them down below, but they're going to lose. You can't skate out of this. And they say the Sixth Circuit has implemented a rule that requires certain Title VII plaintiffs to satisfy a heightened evidentiary standard in order to carry their burden. We conclude Title VII does not impose such a heightened standard. Therefore, the judgment below is vacated and the case is remanded for application of the proper prima facie standard. I mean, this is a pretty quick case. I mean, think about it. It's page 11. I mean, we've only got, Justice Jackson wrote this out pretty fucking quick, guys. Look how far, it's 8 pages. It's 8 pages long of her kicking these people's asses. Now, there's Justice Thomas. He comes out and does his thing. Justice Gorsuch joins him. And he says, I join the court's opinion in full. He says, I write separately to highlight the problems that arise when judges create a textual legal rules and frameworks. Judge-made doctrines and rules have a tendency to distort the underlying statutory text. Remember, Justice Thomas is all about originalism. And he says it's all bullshit. And he says this is an example of it. This is one example of that phenomenon. So he thinks it's not right. He says, I'd be willing to consider whether the framework is a workable and useful tool. He was willing to go one step further. He says the test itself lacks any basis in Title VII. So, chat, you've got two of the nine justices, who said, you know what? This entire McDonnell Douglas thing, we'll just get rid of it, scrap it. That's the interesting part here. This is where it gets interesting. Whiskey 77 says, real quick, for $10. Does this mean that your mods can sue you for discrimination against straight white males? Oh, never mind. None of your mods are straight white males. Well, that's the key. That's the kicker. They're all transitioned. Thanks, Whiskey. Hope you're doing well, man. You guys can see him and 3 Beers on Assholes React Sunday nights at 9 o'clock. Bifron's been a member for 18 months. Thank you for the support, man. I appreciate it. 18 months. Awesome number. Thank you for that support. It says, happy birthday, Sean. Well, happy birthday to you because it's not my birthday yet. Not for another month. So, there you go. I appreciate it. Guys, thank you for the support so far. And they say the background circumstances impose a heightened burden. And he says, he's like, I don't support this. I don't support all of this. He says the additional requirement is a paradigmatic example of how judge-made doctrines can distort the underlying text. And he says Title VII bars any employment under race, color, blah, 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 blah. And he says, to state the obvious, the statute bars discrimination against any individual on the ground specified therein. He says this rule is a product of improper judicial lawmaking. He says this case here, Stewart Organization Incorporated versus RICO. It's a printer and copier company, chat, from 1988. And he said that while interpreting and applying law is the essence of judicial power created under Article 3, that power does not encompass the making of substantive law. Real judicial activism. He says this rule was created by D.C. judges in Parker versus the Baltimore and Ohio Railroad Company. He says applying their own common sense, these judges determined, and it's out of the D.C. Circuit, that extra evidence is required to prove discrimination when a Title VII plaintiff is white. In support of this, the court cited only its mistaken understanding of McDonnell Douglas, another judge-made construct. At no point in the development of this new rule did the court refer to the text of Title VII. Now you guys say, why is the railroad company being sued in D.C.? Railroad companies are protected under the law. They have special laws. They operate in a special world unto themselves. The railroads enjoy such legal privilege. They have their own labor act. There is the Railway Labor Act. There's a Railway Pension Act. And that goes back to the times of the robber barons and when the rail companies controlled America and controlled Congress. They have literally their own little world. And part of that is when you sue them at times, you are stuck in the DC circuit to challenge things. So that's why you see this here. And suing the railroad is never easy because of the railroad. And they have a lot of protection. And a lot, even today, if you guys don't understand that, even today, they control massive amounts of the government. They have a lot of Congress in their back pocket, and it's never going to change. So, he says this rule also highlights how judge-made doctrines can be difficult for courts to apply. And he says because courts lack an underlying legal authority, there's no principled way to resolve doctrinal ambiguities. And he says this rule suffers from this. It suffers. A number of courts have described the rule as vague and ill-defined. The Third Circuit did. The Maryland Supreme Court did. And they say most notably it requires courts to perform the difficult, if not possible, task of deciding whether a particular plaintiff qualifies as a member of the so-called majority. And he says, explaining that we live in a world where it's become increasingly difficult to determine who belongs in the majority. And this is from a 2024 case out of the Sixth Circuit. And they say how a court defines the boundaries can affect whether the person falls in a majority or minority group. Women make up the majority of the United States as a whole, but not in some states and counties. Similarly, women make up the majority of employees in certain industries, but are the minority in others. And then there's white women. They might be a woman as a majority, but then they're, are they white then? Does that majority apply? If they're a black woman, which one becomes the one that applies? They say defining majority is more difficult in the context of race, as racial categories tend to be overbroad and imprecise. They say American families have become increasingly multicultural, and attempts to divide us up into handfuls of groups have become only more coherent over time, citing Gorsuch, which is, I'm sure that buttered up Justice Gorsuch. And even if the courts could identify all of this, courts will struggle to determine which racial groups make up a majority. Black employees in Detroit make up a majority in their city, but not in Michigan or the United States at large. True. It's true. The problems arise over the religion. As with sex and race, a particular religion can make up the majority of the minority, depending on how the population is defined. And the context of religion, the background circumstances, require courts to decide both the plaintiff's religion and how the religion compares with the religion of everyone else in the relevant population. And those tasks are formidable. Americans have different views on example of whether Catholics are Christians. Anybody who's honest with themselves knows Catholics are Christians, whether Protestants are Christians. But how do you define all this stuff? Remember, we've gone through times where, the Italians, they're not white, and now the Italians are white, and the Irish weren't white, and now they're white. It bounces all around. It bounces all around, guys, how this stuff works out. So that is what they're getting at here. And they say, the courts have offered no guidance on how to decide whether the person is a member of the majority. And they say neither this court has squarely addressed the issue. He says instead, judges have been left to their own devices to make these challenging determinations, and they fuck it up. They say the 10th Circuit determined the rule applies to white plaintiffs on the ground the white individuals are members of a historically favored group. The D.C. Circuit said that a white plaintiff, of course, whites are in the minority in the District of Columbia. And that's true, too. It's a majority black area. So, in other words, the courts with this rule have enshrined into them an explicitly race-based preference. Yes, white plaintiffs must prove the existence of background circumstances, while non-white plaintiffs don't need to. And he says there can be no such thing as a creditor or debtor race. And he says such a rule is contrary to Title IX or Title VII. Well, I think there is a creditor race. There's the Jews. I mean, let's be real. I'm just kidding, chat. They say, thankfully, today's decision obviates the need for courts to engage in the sordid business of divvying us up by race. And he says, I simply observe the circumstances as emblematic of the seriousness. He says, for too long, this rule has ruined Title VII. He says, this case involves a second judge-made rule. Relying on precedent, the Sixth Circuit applied the three-step framework developed by this court in McDonnell Douglas. And he says, today assumes without deciding the framework is appropriate. And he says, but this has no basis either in the text of the Title VII. And he says, I previously explained lower courts' extension of this doctrine into summary judgment has caused significant problems. And he says, in an appropriate case, this court should consider whether McDonnell Douglas's framework is an appropriate tool to evaluate Title VII claims in summary judgment. So far, remember, if you want to bring this case, chat, you need 4 votes to get certiorari. Well, right now you have 2 guys, Gorsuch and Thomas. They're the only 2 that agree right now. So they got to work it out for them, to lobby and get it going. So they point out that this case was developed to help courts at bench trials. It brought the litigants in the court to a fair and ultimate question. They talk about the 3 steps, the first, the second step, and then finally the third step here from the McDonnell Douglas framework. We just mentioned all those. We went through them already. And he says the framework was made out of whole cloth. In the opinion of Thomas. I love you. Set yourself. Its contours had no base in the text of Title VII, and as far as I can tell, this court never attempted to justify it on textual grounds. And he says the framework exemplifies how judge-made doctrines can have amorphous bounds. And although originally designed for the bench trial, the framework has taken over the years a life of its own. It is today the presumptive means of resolving Title VII cases at summary judgment. And he says that development has come without this court ever considering, much less holding, that this framework is an appropriate tool for the summary judgment task. And he says, far from going on this here, he says this court has taken steps to limit the relevancy and application of it. And he says, for example, this court has held that it's inapplicable when the plaintiff relies on direct evidence to prove his claim. So it's funny. They even back in 1985, they're already saying this has got a lot of problems. We have said that the framework is inapplicable at a pleading stage as of 2002, and they're still doing it. And in deciding post-trial motions all the way back in 1983. And they say, we have suggested the framework should not be referenced in jury instructions because it's too confusing. And eventually you could go to a jury on that. So this is just an example of how bad this whole thing is. Now, obviously, if Clarence Thomas had his way, he'd abolish Title VII. And I know a lot of you were saying, like, you know, lebased, but that's not happening here today. That's not going to happen with us. So what do we get here? He says, I seriously doubt the framework is a suitable tool for evaluating Title VII claims. In my view, the framework is incompatible. It requires the court to maintain distinctions, and it has created outsized judicial confusion. And he says it doesn't work. And guys, when you talk about Rule 56 here of the summary judgment standard in the federal rules, when you have a motion to dismiss and you start citing evidence and exhibits, you then turn things into what's called a Rule 56, where the court can grant summary judgment. Remember, we talked about this before. Summary judgment allows the court to say, all right, presuming everything in the complaint is true, can somebody win or lose right now? And sometimes you go to summary judgment, the court could go, plaintiff wins. Or he could say, plaintiff, you lose, defendant, you win. And that's the short circuit you can do. Is this funny to me? Yes. This whole thing is funny. What are you guys talking? You guys are talking about Himmler. Jesus. You guys like trying to talk about something important here, and you guys are like just going on about the Anahave movement in the Nazi party. So he points out this rule does not work with summary judgment. And he says it speaks in terms of proving facts by the preponderance of the evidence. And he says that difference is significant because you don't need to establish or prove any elements by a preponderance to survive summary judgment. He says requiring plaintiff to satisfy the framework, as the court described, requires a plaintiff to prove too much at summary judgment. It's a heightened standard. And he says it just shouldn't work this way. It shouldn't work this way. He says instead, the plaintiff should only be forced to present sufficient evidence to create a genuine dispute as whether the employer's reasons were pretextual. I mean, he just goes on and on and on to talk about how this entire thing fails. And he says, for example, this provides the text an unlawful employment or practice established. When any of this was a motivating factor for any employment practice, even though other factors also motivated the practice. So in other words, you could establish a Title VII violation by proving an employer took an employment action in part because of unlawful motive. But he says, on the other hand, if you're in the majority, you have to prove the legitimate reason offered by the defendants were not the true reasons, but were the pretext for discrimination. And that requirement demands more than the text of Title VII. You don't need to establish it was wholly pretextual, just only partially. If any bit of it was pretextual, that can be enough. So he says, in view of this problem, the court has held that the framework should not be used where the plaintiff argues the employer operated with mixed motives. They say instead, it should be limited to cases where discrimination is the sole factor influencing the decisions. It's like if you're dealing with Indians, it'll be the sole decision there. Ben saying I'm white as fuck. How does this change anything for me? The standard you have to argue in court is reduced, which is very helpful. It's an easier case for you to prove. So that's a good thing. That's a good thing. And they say, and even in so-called single motive cases, this test fails to capture all the ways in which a plaintiff can prevail. You know, a plaintiff who cannot establish the prima facie case at the first step or pretext at the third step can still prevail so long as his evidence raises a reasonable inference. The ultimate question is simply whether the defendant intentionally discriminated against the plaintiff. That's the ultimate issue. You're proving he intentionally discriminated against me. Well, how much? I don't have to prove how much. Did he do it or not? So, and he goes on to just reiterate, this test is inapplicable when there's direct evidence of discrimination. And he just goes on to point out this is not workable. He can't stand this. And he says, I would consider the framework should be used for any purpose at all. And he says, in the meantime, the courts can keep using it. This court has never required anyone to use it. And that's important. He's like, you guys don't have to do this. And district courts are equipped to handle summary judgment without it. Every day in almost every context, district courts across the country resolve summary judgment motions by applying the straightforward text of Rule 56. And he says, it might behoove courts to take that same approach in Title VII cases. And he says, I am pleased the court rejects the atextual rule today, but there's other rules he wants to get out of. And that is it for Clarence Thomas here. How much he discriminate from the microaggression of Roman salute? You guys are being a little redonkulistic there. So, Mike is saying, are the courts using McDonnell Douglas first in these cases and not to get overruled later? No. Monica says, did I see that some guy stole Runkle's interview? No. Where is it at? I want to see it. Where is this guy? This guy deserves to be hounded and like chased along. So they totally needs to happen. Who is this scumbag that did it? Did Runkle get on that and take care of it? So but are the courts using this to not get overruled with it later? Well, no, it's because they thought that's what you had to do. They got retarded and they started doing stuff they thought they had to do, and they never asked, why are we doing this? Well, because we have to. Who told you you had to? And once again, this is apparently people misunderstood stuff, and now they're doing it all the time. And this is Clarence Thomas' way of saying, no, don't do it all the time. There's smarter, better things you guys can do. Why are you doing it this way? Why are you doing this way? Kurt did a video on it. Okay. Someone did it's down. He edited Runkle out of the interview. Well, was it Microdots? No. Yeah, give us a name. I want to know who the scumbag is. You tried to watch the interview, but Runkle is not me. Well, here's the deal, guys. Runkle did a phenomenal job at that interview. Couldn't have been a better person on LawTube to do it. Did a phenomenal job. Where's the link? I don't see a link that you guys sent. Oh, the Mike Martin podcast? What a fucking... I want to see this. It's the Mike Martin podcast. Let's see if it's there real quick. We'll take a look, chat. We'll go to YouTube here real quick. Okay. Okay, let me see here. Oh, this is oh wow, this guy really did do it. Check this out.
Good day. Welcome everyone to the Mike Martin podcast. Come on in, come on in. I have arguably two of the greatest defense attorneys.
Oh, he turned his
of
comments
this
off.
century. Fresh off. We definitely have a few questions.
There's nobody.
How did you use social media? Did you look at did you stream it? Did you look at the trial as it was going on? How did that play a part, if so, if any part, in your guys' case?
Okay, chat. And here's the thing you need to do. Guys, when you tell me where it is, put links out. Report this fucker. Report this piece of shit right now. Report him. Flag him. Look at this fucking guy.
Audience, and there's nobody there. So, you know, when I'm trying, like, whatever, a trademark case or patent, whatever it is, you know.
Yeah, I'm also wondering.
Completely impressed with the level of astuteness and intelligence out there.
Oh yeah, definitely, Robert. I definitely understand that too.
Fucking shitbag. Fucking shitbag. Report. Sexual content, violent, harass. Child abuse promotes terrorism, spam, misleading. Yeah, I think it's that. Legal issue. I think it's spam. Legal issue next. Yeah. Copyright. Well, no, I don't want to submit a copyright removal request. What am I going to submit here? Other legal issue. No, it's just spam. It's spam or misleading. There we go. Fuck this guy. Fuck this piece of shit. Fuck this piece of shit. What a scumbag. What a scumbag. So there you go. Yeah, that is just ridiculous. So, all right, guys. So we got done with that. That one's kind of simple, and we have time. If you guys are interested, we could talk about the Skirmetti v. Tennessee regarding the trans treatment of kids. If you guys want to get into that one, we do have time for that. And I didn't realize how fast we get through this one, but we did. So we can get into this one here now. This one's the spicy one. This one's here is the spicy one. You know, if you guys are interested in TTD, here you go. We got some TTD for you. Remember Skrmetti versus the United States versus Skrmetti is the case we listened to recently on. Well, are you guys interested or no? It's not transformative at all. It's not transformative at all. It's meant to replace. It's meant to be a substitute. So therefore, it has no copyright protections under fair use. I'm just protecting the Martin family name. Yes, this is the Chase Strangio one. This is the Chase Strangio one. This is the one where they're like, oh, look, we have a heckin' troon coming in to argue in our case. It's heckin' honest. And then the trans person got up there, Chase Strangio, and oh, yeah, they were very Strangio up there and just kind of shit the bed everywhere. So, but yes, this is that one. We listened to it. And chat, this one was not good. So here we go. Here we go, chat. This one is different. This one was a 6-3 case. This was 6-3. This was not a 9-0. So it's 6-3. I think you guys can figure out who are the 6 and who are the 3. So we're going to get to this here, and here we go. So what is the holding in this? Well, there's a bit of a holding here. So what happened? Roberts delivered the opinion of the court in which Thomas, Gorsuch, Kavanaugh, and Barrett joined, and in which Alito joins in parts 1 and 2B. Thomas filed a concurring opinion. Barrett filed a concurring opinion with which Thomas joined. Alito filed an opinion concurring in part and concurring in the judgment. So you notice these guys are all over the place. Sotomayor filed a dissent in which Jackson joined in full, and Kagan joined in the dissent, joined as parts 1 to 4, and Kagan filed a dissenting opinion. So, and you guys, you notice up here, 118 freaking pages. We are not doing all 118 of them, but we are going to look at them. So, give me 1 second here, chat. Hold on. All right, guys, we're back. We're back. Just read it two. We're not reading it two times. Oh, hold on here. See if I can get somebody real quick. Clyde. Come here, Bubba. Hey. Clyde. Oh, 2.0 feed them. I'm trying to get them to come in here and you're bribing them with food.
All right.
Hey, Clyde, come here.
I show them my new haircut.
Well, I was going to surprise them.
So
Look who's got a haircut today, chat. He's such a good boy.
Why is it 500 degrees in here?
Because it always is.
Jesus fucking Christ.
Mm-hmm. Sweetheart, we're on camera. You know that, right?
I understand that.
She's got to come in here and interfere with the show. You're a producer. You're not the talent.
I think chat probably. It's too different. He's a good boy. Look how soft and pretty.
Yes.
Boy.
He doesn't smell like a skunk anymore, chat. He doesn't smell like a skunk anymore. So, how are you doing, Bubba? Can you give him a woo for everybody? They'd like a woo.
He's a good boy. He's a good boy. Oh my goodness. Oh my goodness. Look at the puppy. Look at the puppy. No.
No.
Not for that.
Ooh.
Oh. He's such a good boy. He's just a good boy.
But yes, Chad, he doesn't smell like skunk anymore, so he's all set.
All right. I'm going to first.
Bye, buddy. I don't have food for you. So go on. Go on. All right. I don't know if they want to, if you grab Lainey, sure. Guys, like to see Lainey real quick. All right, she's gonna grab him here. Anyways, guys, this is Skirmetti. This is the one where they try to bring in, like, look, we have our hecka transgender person, and this is gonna be great. It's like, but it wasn't so good. It wasn't so good at all. Hold on, chat.
It's a lady.
Oh.
She's a hard one.
There you go, chat. Here's Lainey. I know you guys don't get to see her. That's because she's always terrified of everything. So this is Lainey.
She's a good bird.
She smells great too, but she never smells bad.
Yeah, she has the worst breath ever.
And she has dog breath, but like, yeah. Otherwise, she doesn't smell bad. Are you done panicking for a minute?
Do you want to come down? Do you want to come down? Yes, to go
Yeah,
down.
she
Yes, to go down.
does not get picked up, chat. Lainey's very concerned. She's always terrified. She's always terrified. Lawyers keep their dogs in the bathrooms, not this one. Anyways, we're going to move on to Skrmetti, guys. And this is an example of what happens when the Supreme Court steps in to protect them kids. And I need to fix the hold on here, chat. And hold on here. Okay. Sorry, I had to fix that chat. Anyways, we are moving on. Here we go. Yes. So the Skirmetti case gets us going, but this is a whole disaster here. And we're going to get through as much of it as we can. We're going to get through as much of it as we can before we have to get ready for Ethan Klein tonight. So Chief Justice Roberts delivered the opinion of the court, and it's whether the Tennessee law banning certain medical care for transgender minors violates the Equal Protection Clause. An estimated 1.6 million Americans over the age of 13 identify as transgender. Yeah, but then if you go through all the things there, a lot of those people have gender dysphoria who get out of it later. And then who was the book? The book where they talk about God, it's a book Sitchin and Em always talk about. There's a lot of problems. There's a lot of problems with it. It says some transgender individuals suffer from gender dysphoria, a medical condition characterized by clinically significant stress resulting from an incongruence between their identity and biological sex. Left untreated, it may result in severe physical and psychological harm. In 1979, the World Professional Association for Transgender Health, known as the Harry Benjamin International Gender Dysphoria Association, and chat, this is how the DSM got changed. The troons came in and acted like lunatics. They published one of the first sets of clinical guidelines for treating gender dysphoria with sex transition treatments. The standards address two treatments in particular: hormonal sex reassignment and surgical reassignment. And he says they recognize the extensive and sometimes irreversible consequences of hormonal therapy. Wait, I thought you could always just stop. Isn't it interesting? Whoa, now it's a legal fact that this can't happen. Wow, isn't it kind of funny? Isn't it kind of funny? Isn't it funny and a little weird? It's very funny and it's very, very weird how that works. And sex reassignment surgery acknowledges some individuals who undergo procedures later regret the decision to do so. Yes. You see that in Britain with the Tavistock scandal, where untold numbers of children were just shoved through the process and transitioned because nobody dared question it. So in 1998, upheld revised its standards to permit healthcare professionals to administer puberty blockers and hormones to minors in rare circumstances. Today, the standards discuss a range of factors regarding the provisions of treatments to minors. The current standards recognize known risks associated with the provision of sex transition treatments, including potential adverse effects on fertility and the possibility an adolescent will later wish to detransition. So why are we giving them permanent changes? They further state there is limited data on the optimal timing of sex transition treatments or the long-term physical, psychological, and neurodevelopmental outcomes in youth. Really? So we're just turning, it's like people were saying, we're turning kids into fucking guinea pigs. This is shit Mengele would do. This is the type of shit Mengele would do. Isn't that funny, chat? Isn't that funny and weird? They're worried about all the Nazis and they're doing the shit the Nazis would do. Isn't it ironic? Isn't it ironic? They say in recent years, the number of minors requesting sex transition treatment has increased. Yes, it's almost like it's a social contagion. Isn't that funny and weird too? The increase has corresponded with rising debates regarding the relative risk and benefits. In the last 3 years, more than 20 states have enacted laws banning the provision of treatments, while 2 have enacted near total bans. Meanwhile, health authorities in a number of European countries have raised concerns regarding the potential harms associated with puberty blockers. In 2020, Finland found that gender reassignment of minors is an experimental practice and that the reliability of studies is highly uncertain. That same year, England's National Institute for Health, the NIH, and Care Excellence published reports finding that the evidence for using puberty blockers to treat transgender in adolescents is of very low certainty, and the long-term risk with using hormones are largely unknown. Sweden says the evidence of treatment efficacy and safety is still insufficient and inconclusive, and the risk of puberty blockers and hormones currently outweigh the possible benefits. The Norwegian Healthcare Investigation Board. Remember, all these places are so forward-thinking. Like, don't we want to be like Europe? And they say research-based knowledge for hormonal sex transition treatments for minors is insufficient, while the long-term effects are little known. Wow. Wow. Kiki Ray says, I feel bad for the families that fell into this. It's irreversible and their children live forever irreparable. Yes. Yep, irreparably harmed. Yep. Rowan Cowart says, PP poo poo, finally double-digit member. Well, thank you for 10 months. The content lasagna says, this is funny to you, Sean. Yes, it is. It's very funny. Stephen Cooper says, submit a JDAM to that guy. Oh, yes, very true. Should, definitely. I am Bob, who's been a member for 7 months. Thank you for the support, Bob. Says, okay, some reported the slime ball. Well, there you go. Do your part, chat. Wipe him out. Stephen Cooper for $5 says, whoop, whoop, kaleidoscope got his hair did. Yes, he did. He's such a good boy when he gets his hair done. He's such a good boy. So we are on, though. EW says this is live. No. This was recorded April 17th, 2004. So talking about March 2023, Tennessee joined the growing number of states restricting the treatments for minors, enacting the prohibition on medical procedures performed on minors related to sexual identity. While the legislature acknowledged that discordance between a minor's gender identity and biological sex can cause discomfort or distress, it identified concerns using puberty blockers and hormones. In particular, the legislator found that such treatments can lead to the minor becoming irreversibly sterile, having risk of disease and illness, or suffering from adverse, sometimes fatal psychological consequences. And that minors lack the maturity to fully understand and appreciate these consequences. And that's true. We don't let them get fucking credit cards, but we're going to let them chop their wiener off? No, that don't make no sense. Don't make no sense. And they say they further found that sex transition treatments were being performed on and administered to minors in the state with rapidly increasing frequency. They say, notwithstanding the fact the full effects were likely not yet known and are still not known. The legislator also noted that guidelines regarding treatments for minors has changed substantially in recent years, and that these countries place severe restrictions on such treatments after determining there's no evidence to support that the cost outweigh the damages, the pros outweighing the cons. Finally, the legislator determined that there is evidence that gender dysphoria can be resolved by less invasive approaches that are likely to result in better outcomes. He says what they called it Senate Bill 1 responds to these concerns by banning the use of certain medical procedures for treatments to minors. In particular, the law prohibits a healthcare provider from surgically removing, modifying, altering, or entering into tissues, cavities, or organs of a human being, or prescribing or administering and dispensing any kind of puberty blocker or hormone, which is for, enabling the minor to identify with or live as a purported identity consistent with their sex. Or 2, treating purported comfort or distress from discordance between the minor's sex and asserted identity. And they say here, though, among other things, these prohibitions intended to protect the minors from physical, emotional harm by encouraging minors to appreciate rather than become disdainful of their sex. And he says, it's limited in 2 ways. First, it does not restrict it doesn't restrict everything if you're over 18. And second, it does not ban the full administration of drugs to minors. A healthcare provider may administer blockers or hormones to treat congenital defects, precocious or early puberty disease, or physical injury. And that's the thing. There are cases of that. It's a growing thing where children are getting early puberty now, especially girls. Like girls are getting puberty earlier and earlier. And they get puberty blockers for a couple of years till they get to the right age. We don't want a 9-year-old or a 10-year-old going into puberty right away. So you give them like 2 years, 2-3 years, and then they go forward. Similar XP says no one cares, Karen Reed only. Well, we'll do Karen Reed more, okay? Everybody's doing Karen Reed today, so that makes me one of a million. Tomorrow we'll be doing some Karen Reed stuff. So, SB1 is limited in 2 ways. I'm sorry, we got there. The law defines congenital defect to include an abnormality present in a minor that is inconsistent with normal development, but excludes definitions of congenital defect and disease like gender dysphoria, gender identity disorder, and gender incongruence. There are 3 primary enforcement mechanisms to bring action. The Attorney General can do this against any person who knowingly violates SB1. They can enjoin further violations to disgorge any profits received due to the medical procedure and to recover a civil penalty of $25,000 per violation. They can discipline healthcare providers. And then finally, there's a private right of action that enables an injured minor and non-consenting parents to sue a healthcare provider. Notice there's nobody goes to jail. That's also something here that's kind of important because, look, they're not forcing that to happen. And they say there's 3 transgender minors, their parents, and a doctor brought a pre-enforcement challenge. And they say, among other things, it violates the Equal Protection Clause of the 14th Amendment. They moved for a preliminary injunction, and the United States intervened under 42 U.S.C. 2000, which authorizes the federal government to intervene in a private equal protection suit if the Attorney General certifies this case is of general public importance. And it is. And this is the Biden DOJ coming in. So the district court partially enjoined the enforcement of the prohibitions. The court concluded the plaintiffs lacked standing to challenge the law's ban on sex surgeries for minors, but the court held that they were likely to succeed on the challenge to prohibit puberty blockers and hormones. And the court found that transgender individuals constitute a quasi-suspect class. Well, quasi is suspect. If you get the Patrick Tomlinson joke there. But yes, they are sus. Sus as fuck. And that SB1 discriminates on the basis of sex, and that SB1 was likely to survive intermediate scrutiny. And because they're quasi-suspect, you use intermediate scrutiny. That's why that's there. They say, having concluded it was constitutional, the court issued a statewide injunction enjoining all provisions except for the private right of action and the law on surgeries. The Sixth Circuit held the United States and the plaintiffs were unlikely to succeed on the merits. They found that SB1 doesn't classify the basis of sex because the law regulates treatments for all minors, regardless of sex. Notice if they'd said boys can't chop off their penises only, that would be an issue of sex. The court declined to recognize transgender individuals as a suspect class, finding that they're neither powerless nor a discrete group defined by obvious, immutable, or distinguishing characteristics. And he says they've also failed to establish the animus towards transgender individuals as a class was the operative reason behind this. This wasn't done to fuck with transgender people. They say there's considerable evidence regarding the risk with the medical treatments. So what happened here? Well, they move on and they say we granted certiorari. And we get to the 14th Amendment, an equal protection clause, that no state shall deny to any person within its jurisdiction the equal protection of the laws. This must coexist with the necessity resulting with other disadvantage to various groups or persons. And then here's a case, Romer v. Evans. Romer v. Evans was actually kind of an interesting case, chat, as far as what happened there. Romer v. Evans was a case that brought forward Colorado preventing protected status based on being a homosexual or bisexual or LGBT. They literally just passed that. So they passed it that would have prevented any town from recognizing them or government entity from doing that. It was going to be in the state constitution. Sorry, LGBT people are not recognized for protection. And it passed. It was a constitutional ballot measure. It passed overwhelmingly. It was like by at least like 5-10 points. And that's what happened. That is how Romer v. Evans went. The court's like, yeah, you can't do that just because you guys agree. There's no state interest. It was literally just you guys don't want fucking homos around. So the Supreme Court's like, sorry, you can't do that. You can't do that. That's not an acceptable way of handling it. That is how that worked there. Yes, what is a woman? I don't know. I'm not a scientist. So that is where Romer v. Evans comes in. They say, we have reconciled the principle of equal protection. It says, if a law neither burdens a fundamental right nor targets a suspect class, will uphold the legislative classification so long as it bears a rational relation to some legitimate end. And when you guys see IBID, that means they're citing to the thing they just cited. That way you don't have to cite it again. So they're literally just citing Romer v. Evans again. And they say, we afford laws wide latitude because the Constitution presumes that even improvident decisions will eventually be rectified by the democratic process. Meaning, if the public fucks up, they'll unfuck it. Generally not, but that's how they look at it, and that's what they argue. So they're going to do this, and they're asked to decide whether it's subject to the heightened scrutiny under the Equal Protection Clause. And we hold that it's not. It doesn't classify any basis that warrants heightened review. And they say, first, it classifies on the basis of age. Healthcare providers may do whatever they want to anybody 18 and older, but not to minors. Second, SB1 classifies on the basis of medical use. Healthcare providers may administer puberty blockers or hormones to minors to treat certain conditions, but not treat gender dysphoria, gender identity, or gender incongruence. They say these classifications that turn on medical use are subject only to rational basis review. Remember, rational basis review, chat, is the basis rational? Yes. Do they have a basic reason for it that's believable? Yes. They don't have heightened scrutiny. Rational basis is the basic bitch of constitutional things here. And when you get to rational basis, there's not, it's related to a legitimate government purpose. And they could say that here. They argue SB1 is heightened scrutiny because it applies to sex-based classification. They say we disagree. Neither of the above turn on sex. It regards minors and medical uses. Medical uses of minors are not protected that way. And they go on to explain here, in this case, that on their face, this is a case for Vaco, that New York's ban on assisted suicide, nor its statutes permitting patients to refuse medical treatment, treat anyone differently from anyone else, draw any distinctions between the persons. And they say everyone, regardless of physical condition, is entitled to competent refusals for unwanting life-saving treatment. They say no one is permitted to assist a suicide. And that was the argument that was raised. Like, well, look, we have those problems. And if you guys remember Jack Kevorkian, he was helping people where he would come in and set you up with the IV drips and you'd hit the button and it would slowly kill you. They say, well, this is different. You're not allowed to help in a suicide. So you can't bring that up at all. Now, they bring up, they define the prohibited medical care based on sex. They're like, but look, it involves our sex. And at times they suggest that the basis of sex is because it prohibits references sex. They also claim that it's a sex-based classification because application of the law turns on sex. And neither argument is persuasive because it doesn't. And they point out merely referencing sex is insufficient to trigger heightened scrutiny. Just as neutral terms can mask discrimination, gender-specific terms can mark a permissible distinction. They say such an approach would be especially inappropriate in the medical context. Some medical treatments and procedures are uniquely bound up in sex. And the FDA recognizes that research has shown biological differences between men and women, may contribute to variation seen in the safety and efficacy drugs, biologies, and medical devices. They say, indeed, the agency frequently approves drugs for use only by one sex. It says the FDA encourages inclusion of male patients in breast cancer trials. And many breast cancer treatments approved for women only. They say the FDA approves the second drug to prevent HIV as going on part of efforts to tend to the epidemic. Hold on here, chat. What are we doing in this? So, in the medical context, the mere use of sex-based language does not sweep a statute to the reach of heightened scrutiny. And they say we reject the argument that it turns on sex. Once again, it's about minors getting treatment. The plaintiffs in the dissent contend the adolescents whose sex is female can't receive blockers and present as male, but an adult whose biological sex is male can get blockers or estrogen to live and present as a female. But an adolescent whose biological sex is female can. Like that's not true. It's not how that would work. They contort the term of medical treatment, though. It's special. You have to do the right things. It's all about the disease or conditions you treat. Just like different drugs can treat the same thing. Would you like Advil or Tylenol for your headache? The same drug can treat different things. Like you take Dayquil to ease your cough, fever, sore throat, and minor aches and pains. It says for the term medical treatment, it must necessarily encompass both the given drug and the specific indication for which to be administered. And they say, when understood from here, it does not classify on the basis of sex. They say, for example, when a transgender boy who's a female takes puberty blockers to treat his gender incongruence, he receives a different medical treatment than a boy whose biological sex is male who takes blockers to treat his precocious puberty. And he says, in turn, this restricts which of these medical treatments are available to minors. And they say under SB1, a healthcare provider may administer blockers or hormones to any minor to treat a congenital defect. Now, they point out that it's all about healthcare providers may not administer blockers or hormones to a minor. They say the application does not turn on sex. What am I looking for here? Oh, we went a little too far, chat. I was looking at the wrong thing here. Hold on, chat. I need to take care of this real quick here. Give me 1 second. Be right back, you guys. Be right back. I'm not going out for milk and smokes. And they point out here, though, there's no masking of sex-based classifications. The law doesn't prohibit conduct for one sex that it permits for the other. Under SB1, no minors can get it. Minors of any sex may be administered puberty blockers for actual medical problems. And they say that enabling this to treat purported discomfort or distress between your sex and your identity doesn't count. They say that they point out that Sotomayor is doing an analogy to a hypothetical law that prohibits minors from attending any services, rituals, or assemblies that done for the purpose of allowing the minor to identify with a purported identity inconsistent with the minor's religion. Now, he says such a law would plainly classify on the basis of religion. And they say that a Jewish child, based on their argument, can visit a synagogue but not a church, while a Christian can visit a church but not the synagogue. And they say, though, the prohibitions of these puberty blockers enable a minor to identify or live with as a purported identity inconsistent with their sex. And they say this is simply a prohibition on the prescription of puberty blockers and hormones to treat gender dysphoria, to treat gender identity disorder. Or they say, or gender congruence. And they say a law prohibiting attendance at religious services is inconsistent, and that may trigger heightened scrutiny. A law prohibiting the use of drugs does not. And they say, finally, we reject that this enforces a government preference. The plaintiffs note that Tennessee has a compelling interest in encouraging minors to appreciate their sex, and in prohibiting medical care that might encourage minors to become disdainful of their sex. I mean, this can go back to, you can even make the argument for, this is why, for example, like cigarette companies, you can't do it that way. They lost their cases regarding their advertising. And it might encourage them because disdainful of their sex. Well, they have an interest in, making sure people don't smoke anymore. So the state has a lot of interest in the health of its people, and the health and welfare and safety. This affects you as an analog sexual. Oh. You guys are funny. You guys are redonkulous. And they say, to start, the allegations of sex stereotyping are misplaced. And they say, true, the law does classify on the basis of sex may fail scrutiny, but where the classifications are neither covertly nor overtly based on sex contrast, that's it. And they say, we don't subject the law to heightened scrutiny unless it's motivated by an individual, invidious discriminatory purpose. And they say, no such argument has been raised here. And they say, regardless, the statutory findings do not evince sex-based stereotyping. Now, think about this, chat. This is Roberts, and he just keeps on laying into them. They don't got nothing. They don't got nothing. He just keeps hitting them. So they say, and they fail to acknowledge that Tennessee found the prohibited treatments are experimental and can lead to later regret and are associated with harmful and sometimes irreversible risk. And they say the interest in encouraging minors to appreciate their sex and prohibiting medical care that might encourage minors to become disdainful of their lives, that's going to go well. They simply reflect the state's concern regarding the use of the blockers to treat gender dysphoria. Remember, they're not going to allow it. They're not going to sit there and cheer for it. They're not going to sit there and make like Fauci models after it's all done. Like, these people think that's going to happen. They say, nor is it the proper time for the state to be protecting minors from procedures that encourage them to become disdainful of their sex. Now, they keep going on with this, and they say, though, this court has previously held that transgender individuals are suspect or quasi-suspect. And in this case, it does not raise the question, because transgender people are not classified on status. And they say, so as we explained, SB 1 includes two classifications. Healthcare providers may not administer two puberty blockers or hormones to minors, which could be serious. They say that there are two classifications. The healthcare providers may not assist with puberty blockers to do this to minors of gender dysphoria, gender identity disorder, or gender incongruence. And they say plaintiffs do not argue the first classification turns on status. And our case law forecloses any such argument as the second. And he says, we have explained that a state does not trigger heightened scrutiny by regulating a medical procedure that only got one vote unless the regulation is a mere pretext for invidious discrimination. So they go through these cases here, and they have this one, Geopolitics versus Aiello. And they say that, for example, this California insurance company excluded coverage of disabilities resulting from pregnancy and did not discriminate on the basis of sex. And they say, reaching the conclusion, we explained the program did not exclude any individual from benefit because the individual's sex, but rather removed one physical condition from the list of dispensable disabilities or compensable disabilities. And they say, we observe the lack of identity between the sex and the pregnancy-related workers to become clear on the weekends. And they say, wait, did I lose my spot chat? I didn't highlight. I was trying to move along here, so. God damn it, I lost where I was. I just lost where I was. IUDs for men. No, there are no IUDs for men, chat. So they talk about the insurance here. The California insurance program, we explained, divided recipients into two groups: pregnant women and not pregnant persons. And they say because women fell into both groups, the program does not discriminate against women as a class. I mean, I don't see how that works, but okay. Thus be conducted even though only biological women can become pregnant. Only biological women become pregnant, chat. I don't know about you, but, you know, that really just means you want to think about...
Was this story based? Yes.
Absolutely based. Absolutely based, chat. Absolutely based. And not every legislative classification concerning pregnancy is a sex-based one. And they say by the same token, it doesn't exclude anybody from treatments on the basis of their transgender status. So SB1 divides minors into two groups: those who might seek blockers or hormone treatments to treat the injuries, and to protect those who might see puberty blockers or hormones to treat other conditions. They say because only transgender individuals seek puberty blockers and hormones for the excluded diagnoses. The first group indicates only transgender individuals. The second group, in contrast, encompasses both. They say, thus, although only transgender individuals seek treatment, the gender identity disorder, ultimately, there's a lack of identity between the transgender status and the excluded medical diagnosis. And they say they haven't argued that SB1's prohibitions are more pretext. And they say, because you haven't shown any pretext, you haven't shown, oh, we're doing this just to punish the gays. Well, you haven't that there. Now, they cite a case here at Bostock versus Clayton County. And you've seen this before a couple times, chat. But yeah, anyways, this involves being fired for being gay or transgender, violates Title VII. Undischarging an individual because of their sex. They say, we reason that Title VII's because of incorporates all the things that are here. They say, applying this test, we held that for an employer to discriminate against employees for being homosexual or transgender, the employee must intentionally discriminate against individual man and women in the part of sex. And where is he? Hold on. Let's see here. Where is the thing I needed? We'll get it later. They talk about in these cases, the employer would have penalized a member of one sex for a trait or action and tolerates it in the others. So they point out that ultimately... Oh, hold on one second. All right, sorry, I heard a noise and I was like, what the hell was that? They say, we haven't considered whether the reasoning reaches beyond Title VII. They say, for reasons we have already explained, changing a minor's sex or transgender status does not alter the application. If a transgender boy seeks testosterone and she does dysphoria, that could happen. SB1 prevents a healthcare provider from administering it. And they say if you change his biological sex from female to male, SB1 would still not prevent him the hormones because he thought he would lack a qualifying message for the testosterone, which as some people, take and test, it's good stuff. There's no congenital defect. There's no precocious puberty, disease, or physical injury. So they say the transgender boy can receive testosterone only if he had one of those problems. And if he had such a diagnosis, he could attain them regardless of his sex or his status. They say undergoing the reasoning, neither his sex nor his transgender status is the but for of his inability to obtain testosterone. Now, they go on to talk about Sotomayor and just how she's being crazy here. And they say to illustrate this argument, the dissent posits a minor girl with facial hair inconsistent with her sex. Now, what can happen? Well, you can get puberty blockers to suppress the hair growth. Changing the minor's sex to male prevents the minor from obtaining the same drugs for the same purpose. They say any corresponding charge in the diagnosis simply reveals that both sex and causal factors are at play at ICE. They say that its sense reasoning overlooks a key distinction. In Bostock, an employer fired a homosexual male for being attracted to men, while retaining the female straight colleague has discriminated on the basis of sex, because it penalized the male for a trait, attraction to men. So wanting to put a man's wiener in your mouth, that makes you protected. Oh. I like that. Well, that's his attraction to men. So once again, they say he becomes a straight female whose attraction to men the employer tolerates if he was a straight woman. So they keep pointing out that the minor girl with the unwanted facial hair is inconsistent with her sex. Well, she should have. It doesn't work. If she has a diagnosis of male pattern hair growth, you can get puberty blockers or hormones. You can give her some reverse Rogaine. And they say the rational basis of all of this doesn't work here. And they say where there's existing plausible reasons for the relevant government action, our inquiry is at the end. And they say that this clearly the law does all this. And they point out kids don't have maturity. They can't appreciate the life-altering consequences, and many express regret. And they say at the same time, like there's all kinds of problems with this. And they say Tennessee conducted an ongoing debate among medical experts regarding this. And there are so many problems here about what this does. And they say they also decline the plaintiff's invitation to second guess the line it draws. They say this all might be true. But as Tennessee determined, those drugs create greater risks when administered to treat gender dysphoria and anything like it. We afford states a wide berth in the discretion to pass legislation. The fact the line has been different ways before doesn't mean you can throw it to the wind. That doesn't change the court's rulings. So they bring up that this is all the things here are things we addressed before. So what happened in England? They said, hey, we characterize this by using puberty blockers. And they're like, oh no, please don't do that. They say it's remarkably weak. Like, this is not good. And they concluded there's no good evidence on long-term outcomes. And then this is the Cass independent review. You guys have probably heard of this before. And they say the results of studies are exaggerated or misrepresented by people on all sides of the debates to support their current views. So they're all in bad faith, chat. In response to the report, NHS England enacted prohibitions on the administration of puberty blockers to new patients under 18 outside of research settings and instituted a process for reviewing referrals for hormone for adolescents under the age of 16. So they had to deal with who they had still, and that creates a bit of a problem for them. That creates a bit of a problem. And they say, we cite this report and the response not for what they might provide on the ultimate question of laws, but it does show the open questions regarding the factual issues. And it's the issues regarding medical authorities and other regulatory bodies. And they say this affords little basis for judicial response in absolute terms. And he says this carries with it the weight of fierce scientific and policy debates. Well, there's not a lot of scientific debates anymore. This shit is insane. That's what we know. We know it's all crazy. We know that, like, it's not good. We know people shouldn't be doing it. We know that we shouldn't be doing this. We should be leaving these goddamn kids alone. We should be leaving the kids alone. We should be leaving the kids alone, and we're not doing that for some reason. And it's sad because it's all we're doing is hurting children. So, hey, teacher, leave your kids alone. So, that's kind of where we are. Territory says, what will you do if Clyde wants to bat for the other team and wants to change a jersey? Well, I mean, it's not going to happen. He's a dog. There's always a white girl out there for him. So, you know, he's not going to, there is no white boys fuck dogs song. So, but yes, leave them kids alone. They say the Equal Protection Clause does not resolve us to do anything here. Our role is not to judge the wisdom, fairness, or logic of a law. Is it constitutional? Yes. Is there any reason why we have to overturn it? No. They made a bad choice. Well, then you fucking deal with it. They tell them to suffer. Suffer, Tennessee. Suffer, trannies. Total tranny death. So there you go. And they talk about the trannies and what they want to do there. Gross propaganda against women. El D'Agusto says, EVS says you're not allowed to make white girls have sex with dogs jokes. Why not? They do. White girls fuck dogs. That's not a joke. That's a real thing. Ski Man says, Sean, don't get me wrong here. I like Runkle, but he doesn't grab my attention as you in the chat does. And I've liked Runkle since the Dept trial, and I get that. But Runkle did a phenomenal job with the interviewing of those two guys. I don't know if I'd have been able to do as good as he did. I think they did a great job. So I'm just going to leave that alone. I think I'm just going to leave that one alone right there. Oh, let me see here. No, we're still good. But anyway, Ski Man for £5 sterling. The King Sterling. So actually, no, it's not the King Sterling because you're up in Scotland, so we can't. Marlene says, Sean impresses me with the breadth of his knowledge on a wide range of topics and his good sense of humor. Well, thank you, Marlene. Stevie Cooper says, Colorado for $10. Colorado went from Second Amendment 2 to the first MiG-15 faggot governor in 25 to 30 years. Totally legitimately, yes. There was no steering of that happening. John Coleman is a new member. Thank you for re-upping, John. Then Armand says, member for 6 months, is this worth a cup of coffee? Oh, I got the little Clyde boy. Anetti and Yanetti and Alessi stuck around for 2 hours. I guess they thought Runkle did okay. Yeah, I'm sure. Here's the thing I will tell you too. Yanetti and Alessi, those guys strike me as super, super genuine and very nice people. And, and the way they came across Runkle was because of Alessi's daughter. So I think they really wanted to give them a chance. They really thought this was going to be a good one. And I think they realized this case was different. We're in the social media age. Social media had a great thing. And the social media has been like the one thing that's had Karen's back the whole way. So I think they really wanted to kind of give back to the community. And I think that's awesome that they did. So I think it's great. Alessi's 50 years old. No, Alessi's 67. Alessi can collect Social Security if he isn't already. So, but yes, guys, I enjoyed the conversation. If you haven't watched it yet, go watch it. It's good quality content. As far as, Thomas wrote out a lot here, and it's interesting. It's not really like that stuff isn't really the important part here because a bunch of stuff agrees. I don't care that people agree. I kind of want to know what does the dissent say? Because really, what you do doesn't really impress me. Like, I get it, you're dogpiling on for a different reason. I mean, because look at this. You just like all the different things here. Part 2A3. It's like, what is this? Let's just get to someone else because this is just goofy. So, here you go. So Justice Sotomayor, who when Justice Jackson agrees and whom Justice Kagan would always agree. They're all put together here. And, did they team up and they're like, is this the crime fighting team now? They can just like take their glasses off. It's like, zoom. So they point out that you can't treat people differently based on sex. And that's a case United States v. Virginia. They say if a state seeks to differentiate on that basis, it must show the sex classification serves an important governmental objective. But they're not discriminating on that basis. They say today the court considers a Tennessee law that categorically prohibits a doctor from prescribing certain medications to adolescents if and only if they will help a parent identify or live with a purported parent. I mean, that's as long as it's inconsistent with the minor's sex. And they say, in addition, anybody who does this, the law conditions the availability of medications on sex. Male but not female adolescents can receive medicines that help them look like boys. And female adolescents can receive medicines that help them look like girls. I mean, what's not the love? I mean, that makes a ton of sense, doesn't it? Isn't it interesting how they put it this way? And when you say that, you're like, I listen to that and I'm like,
Was this story based? Yes.
It's pretty very clear cut to me. I like that. What is the problem here? Thomas should have just wrote TTD. That would have been epic. Oh no. They say, so hold on. And they say, but this doesn't work. They say the majority subjects a law that plainly discriminates on the basis of rational basis review. They say by retreating from a meaningful context, right exactly to where it matters most. The court abandons transgender children. Aww. And their families with political whims. In sadness, I dissent. Well, nobody cares, Sotomayor. Nobody cares, Sotomayor. Like, come on now. What do they say here? Well, they ignore all the stuff coming in from Denmark, Norway, Scandinavia. They ignore all that because what do they get to here? Well, there's a high as 40% of prevalent suicide attempts. I mean, like what? Like, oh no! Like we're not using the heckin' talking points. Like, wait, the scientists are doing something. Well, what do they know? As many as 1/3 of transgender high school students attempt suicide any given year. It's all garbage. It's all hot garbage. And they say this is why the American Academy of Pediatrics, the American Medical Association, the APA, the American Psychological Association, and the American Academy of Child and Adolescent Psychiatry all agree that hormones and puberty blockers are appropriate and medically necessary. Okay, but guess what? How many organizations have you not listed? I'm betting you listed quite a few that don't exist anymore. Or that just don't exist and you were just making holes and had her. I just don't get it. I just don't get it. This is just reading. This is just reading right now. They talk about Ryan Rowe, now 16, felt as early as elementary school that he was a boy. You're not a real boy. Before puberty, Ryan thought there wasn't much of that edge between boys and girls. And then he could manage existing in the middle. As puberty approached, however, he grew distrusting of his friends. Ryan thought there wasn't much of a difference between boys and girls. He could manage existing in the middle. He grew anxious about the impending changes of his body. He started throwing up every morning before school. Well, his voice changed. So, I don't see... This doesn't make any sense because if Ryan is 16 and he felt he was a boy, that means Ryan was a girl. Girls' voices don't really... Hold on. I was going to say, ladies, your voices don't really change when you hit puberty. As his voice changed, Ryan contemplated going mute. Okay. How much drama are we doing now? How much drama are we farming tonight, guys? How much drama are we going to farm out of this one? This isn't a Supreme Court opinion. This is fucked up. This is ridiculous. Eventually, after 2 years of psychotherapy and extensive consultations, Ryan's physicians prescribed him testosterone, and Ryan began to find his voice again. He started raising his hand in class, participating in school, and making himself in the mirror. Ryan attests, gender-affirming health saved his life. Did it really? For Ryan's parents, it was not an option to cut him off from this care. Worrying about his ability to survive, losing him would break me. Well, that would break any parent. LW2 began to question her gender as early as 4th grade. At the time, she felt like she was drowning and trapped in the wrong body, often sick at school because she didn't feel comfortable using the boys' bathroom. At age 13, they sought out treatment. 13 years old, guys. Fuck. Blockers and estrogen prescribed to LW. Some Mengele level shit. We have a happy and confident daughter who is now free to be herself. Is she really free? Oh my God. And they say, if we're in this, hold on, shit here. They say, I couldn't let this happen. Echoing a similar refrain, John Doe and his family attest that John felt from an early age, he was a boy. You're not a real boy. You're tranny, Harry. I'm what? He chose a male name for himself around the age of 3. As puberty approached, John grew terrified of undergoing what he saw as the wrong puberty, recognizing that some of those changes could be permanent. So, okay, so we're going to make some other changes that are permanent. Oh, no, I can't fix that one. So I'm going to just make a permanent decision I can't fix regardless. Like, really? Really? Like, come on. You know. Yes, that 13-year-old's name, Albert Einstein. Yes, if you say you're a girl, mommy and daddy will get attention and nobody will be allowed to bully you. But yeah, this is just, buddy. Oh, buddy. Oh, buddy. So, his mother, who shed many tears, acknowledges that John's gender transition has not been easy. Yet she attests John's access to treatment is one of the things that gives her hope he can live and have a fulfilling life. I mean, so I talk about these 3. These are the 3 kids. John, Ryan, and LW. Loser, which one? And this is the case that actually came up from Tennessee, was LW v. Skirmetti. Because they're a juvenile, it became an abbreviation because juveniles are entitled to privacy. All 3 judges accepted the premise the statute treats minors differently based on sex. They agreed to it, but then they still refused to apply it. Yeah, I don't think they do, but hey, whatever you got to tell yourself, remember, that guy will... I just don't know how you get this. I just don't know where you go from here, guys. I'm distracting us from World War III starting. What happened? Did more stuff go down? Hold on, chat. More strikes? Oh, wow. Okay, that's going to be interesting. Hold on. All right, we're going to keep moving. I thought you guys made it sound like it's like the bombs are on their way or the B-52s are in the air. Sorry. Oh, yeah, Trump was addressing us? He did? The NSC has been called to a meeting in the Situation Room. That's generally where the National Security Council is meeting right now. That's not impressive. Dale Jr. is now 1 for 1 as crew chief. Well, that's good news. Also, chat, I have to pay the water bill, so give me 1 second. I'll be right back. All right, chat. So, also, I hope this isn't pee, but it's going to dry out my skin. All right. Patrick Allen says the 24-hour Nürburgring is going on. I didn't know that. Are the B2s that go in Diego Garcia? Well, there are a bunch of them there. Apparently, the entire B2 fleet is out of the country right now, it looks like. And at Prince Sultan Air Base in Saudi Arabia, there are like a shitload of B-52s and a bunch of fighter planes. So it's something. This is either a big attempt to scare the Iranians, or we're going in to handle some business. I don't know. So we'll find out. We'll find out. So my name would be Piss Hands. Well, I mean, that's better than other names. So all right, chat. We're gonna keep going here, but look at this, what they keep doing. They just say this is so wrong. It's so mean. This is so mean. This is just, it's not fair. They say states may not enact laws that classify those on basis unless they can pass through a daunting two-step examination known in our cases as strict scrutiny. And we're dealing with minorities. They often face systemic barriers to vindicating their interest. Is it narrowly tailored to achieve a compelling governmental interest? Is it narrowly tailored to achieve a compelling governmental interest? And they're trying to argue this is just like racial discrimination. Is it really? Is it really? Now, they do talk about for nearly half a century, the Supreme Court's done intermediate scrutiny to classifications that distinguish between males and females, but this doesn't. It doesn't. It doesn't do that. They're saying intermediate scrutiny is a core tool for sex-based laws. It doesn't, though. They say it plainly classifies, but it doesn't, though. They say, though, if it's done if a minor, identifies or is inconsistent with their sex. So it's not based on sex, it's based on their age. And they say physicians can continue to treat for physical or chemical abnormalities present that are inconsistent with normal development. So I don't see how you can make this argument. But what does that mean in practice? The wisest Latina dares ask us, what does this mean in practice? Yes, we're all technically minorities. The individual is the smallest minority of all. Justin Time says not B-52s. We'll get to that in a second. There are B-52s. They're at Prince Sultan in Saudi Arabia. The B-2s are at Diego Garcia. So they say physicians in Tennessee can prescribe blockers to help a male child, but not a female child, look more like a boy. And to help a female child, but not a male child, look more like a girl. Okay? Put in the statute's own terms, doctors can facilitate consistency between their physical appearance and the normal development, but they may not use the same medications to facilitate inconsistency. Yes, we're not going to allow you to Mengele little fucking kids. We're not allowing you to be Joseph Mengele. God, is this so hard? Is this so hard? You understand. You're not allowed to Mengele little fucking kids. We don't want this in America. Tennessee does not want that. You're not allowed to butcher little fucking kids. Seriously. Seriously. Mangling or mengeling? Both. You're mangling children by doing mangling. 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 You're doing mangling by doing mangling. There you go, chat. That's how we're going to say this. You can do both. Oh, follow the money. Yes, the insurance companies pay for all this stuff. There is so much money in paying out for hormone treatments. There's so much money in the surgeries. There's an entire industry supported by bucks like this. Insurance payouts are massive for these things. She says a simple analogy illustrates the point. Okay. Suppose Tennessee prohibits any minors from attending assemblies. Okay. That are inconsistent with a kid's religion. No one would dispute that such a rule classifies on the basis of religion. Okay. But are you arguing that changing your gender is just as flippant as changing your religion? Changing your religion can have permanent consequences, because if you shun Christ as your Lord and Savior, you will go to hell if you do that and don't repent before you die. But you can always fix that. You can always come back to Christ at any point in time and confess your sins, and he will accept you again into the fold. So this isn't like that. This isn't permanent in that way. Yes, it's not an analogy because it's not analogous. Well, Apix says, I've heard this before, but if things were different, wouldn't they be different? Yes, this is a woman argument. Hashtag woman moment. And thank you, Cecilia. Runkle just got interviewed by Rebel News? Fuck yeah. Man, I'm so happy to see the people I do this stuff with are just kicking ass like that and getting everywhere. Let me see here. Yes, HRT is dirt cheap out of pocket, but that blocker in particular is easy $2K a month. Well, you can get, but you're not having doctors manage you and stabilize you and treat you and give you the other things to make sure you address other maladies and problems that occur with the transitioning. That's where the money is. And the therapy and the psychiatrist and all that shit that goes along with it and the aftercare. All that stuff is where you make the money. So. Yes, it's like grabbing a chunk of uranium to do chemotherapy. Yes, it will work, but it might not in the right way. Yes. And Marlene says, and leaving Islam may be hazardous to your health. Yes. So it might be permanent leaving Islam. So. All right. A Jewish child could visit a synagogue but not a church, while a Christian child could attend a church but not a synagogue. They say, consider the mother that contacts a doctor concerned her adolescent child has begun growing unwanted facial hair. This hair growth has spurred significant distress because it makes her child look unduly masculine. The doctor's next step depends on the sex. Well, if the boy looks unduly masculine, no one's going to say anything. Also, if a kid starts growing a beard early, you know what? Kids are going to, they might make fun of him for a second, but then he's going to look like a badass motherfucker. And you can tell I don't think Sotomayor has kids, but when you're a kid and you start growing a beard and you can start growing beach fuzz, you're kind of cool when you can do that as a boy. That's kind of a big thing. That's kind of a big thing when you're a boy and you can start growing facial hair, ladies, if you didn't know that. When you're not like a full beard, but if you can get going, it's kind of a thing that's important. Because then that kid could also start buying alcohol and cigarettes as he gets, a little older and things like that. And you go to the grocery store and buy a case of beer when you're 16 and I'm not saying I've ever done that, but I'm just saying, I may have done that at some point, multiple times. But yes, the more facial hair you can grow, it's very important. The only exception is the patchy beard. Yes, that's true. If you have the patchy, shitty beard, you're fucked. But yeah. Yes, like the phrase, putting hair on your chest is manly, part of being a man. Yes. Yup. Yup. Yeah, you're looking like the chadliest of chads. That's never a downside. If the patient was identified as female at birth, SB1 allows the physician to do it. What if the adolescent is identified as male? That doesn't work. Like, he's like, I don't want to look like a boy. It's like, well, 99.99999% of you do. SB1 precludes the patient from receiving the same medicine. Yes. Not consider the parents who tell a Tennessee pediatrician their child has been experiencing unwanted but medically benign buildup of breast gland tissue. Notice she won't even say teenage child, meaning son growing boobs. Because if the girl's growing boobs, that's great. Again, the next move is, what are they identified by? When a child identified as female, experiencing the same or more distress must be denied the prescription. Unless you could say it's precocious or you could say it's causing your back problems, there's ways to lie if you really wanted to get around it. So, and they say Tennessee concedes the point. It admits that a prohibition on wearing clothing is inconsistent with the wearer's sex, would trigger scrutiny and would be prohibiting professionals from working in jobs inconsistent with their sex. It'd also be completely retarded. It wouldn't even survive a rational basis. And they say that SB1 draws the same kind of line. For some treatments that can help adolescents look and feel more masculine, a male minor can have the treatment and a female minor cannot. Well, yeah, it doesn't work this way. A long line of equal protection precedents confirm that much, that equal protection asks only whether the law differentiates on the basis of gender. They say that is why an Alabama statute that authorizes the imposition of alimony obligations on husbands but not wives is a problem. And that was a case that happened. Or v. or. So you want to, is it Mr. Or Mrs. Or one or two? They say it's impossible to discriminate against a person for being a homo or transgender without discriminating against that individual based on their sex. And they said, would changing the employee's sex have yielded a different choice by the employer? And they say the answer was clearly yes. And they're arguing here that's the same thing. And it's like, it's not, though. It's not. And they say by depriving the adolescents of the blockers, you're not doing things that you give them the chance to tolerate. And oh, sorry, Mindset was just DMing me, just making sure it wasn't. Let's see here. All right. So notwithstanding this, they say this should be intermediate scrutiny. It's like, but it's not. It's not, Sonia. It's not. We're not doing intermediate scrutiny here. We're not doing intermediate scrutiny. You're not making fetch a thing. You're not making fetch a thing. And ultimately, we get to the end. We get to the end here. And what does she say? And, we're not doing Justice Kagan because she does a little quick thing here. And she says, though, and notice what she does here, because at the end, she does blow things off. And she says that the United States requested of this court was confirmation that intermediate scrutiny applied. That's all the government was asking for. On remand, the courts could have taken due account of the recent developments and underscored the need for flexibility, including the report about the NHS. Yet the majority inexplicably refuses to take even the modest step of requiring Tennessee to show its work before the lower courts. Notice she just glosses over, look, we might have a big problem here with it. It's because there's a big problem with it. She says, because sex determines access to covered medications, it's clearly inconsistent and it's a sex classification. And the majority refuses to call a spade a spade. You're not supposed to use that. That's generally calling a spade is a racial term. Because a spade is what you call a black person that's back when you call them a nigra. Like you got to be careful using that term nowadays, Jack, calling a spade a spade. Instead, it obfuscates sex classification. She says the court's willingness to hear does irreversible damage. Wow, isn't that ironic? We're worried about irrevocable damage. Permanent damage. Wow, I think I know there's a lot of permanent damage going on, huh? Think about that with gender reassignment. That's permanent damage. Isn't that ironic? Isn't it ironic? So, there's no constitutional justification for this result. I dissent. And then Kagan she goes for a page here. And she says the court is wrong in not subjecting SB1 to the proper examinations here. So she joins most of Sotomayor's dissent. Okay. And she says, though, the law should survive only if it is substantially related to the achievement of important governmental objectives. The point of applying that test is to smoke out invidious or otherwise unfounded discrimination. Just like Romer v. Evans. It clearly came out that, no, we just don't like homos. Well, you can't do that. You can't pass laws just because you don't like homos. You're not allowed to do that. She says, I take no view on how it would fare under heightened scrutiny. Well, I think you do know. I think you're going to say it's going to fall apart. The evidence here is extensive, complex, and disputed. And the Court of Appeals, because it only applied rational basis, never addressed the relevant issues. And she's saying still more, both the plaintiff and the government asked this court not to itself apply heightened scrutiny. But only send this back down. And she says, I would start and stop at the question of what the test must satisfy. And she says it's heightened scrutiny. Therefore, I respectfully dissent. Now, that's where we're at with this. That is where she says. And ultimately it's going to be the intermediate scrutiny because it's not strict scrutiny. It's got to be narrowly tailored for a compelling government interest. Okay, well, intermediate scrutiny, it serves an important objective and it's related to achieving that. And that's where you kind of get to gender and other things like that. Neither Kagan or Sotomayor have children. Well, there you go. 6-3, yes, JDK. It was 6-3. The liberal wing and the liberal wing and the conservative wing split. Obviously, you can tell who was on this side and who was on that side. Barrett actually did a good one on this one here. Thank you, Cecilia. Content Lasagna saying, let's start a question with so. It's the Mercatus school of retort. So there you go. That is, I agree. But the problem is she probably had a massive run on. This is a pretty big sentence when you look at it. When you're looking at the sentence itself, here's that sentence. Here's that whole sentence. But she can't keep going. That's a big sentence already. And she says, so I will both start and stop the question that it must satisfy. She wrote, therefore, I would both start and stop. But she didn't. Yeah, that was kind of lazy. Lazy on her law clerk's part. Yes. Moloch needs more children. Feed me a child's soul. So there we go, guys. That's kind of the doubleheader here for the Supreme Court. Make America whole again. Well, we can't make those kids we mangle it whole again. A couple of them have impermissible holes now. Cyanide Cologne says, I think Sean has an Edward pass. He's a defense attorney. Well, it doesn't work. It does not work like that. Remember, you can only say this stuff in court. Remember, if an N-word is used by a party as part of their statements or their testimony, I can use it. I can't just go into court and go, like, it just doesn't work that way. So, it's like calling them shines or moulignons. Yes, very true. Foley says, my son was unexpectedly called to fly out last night. Couldn't tell me where. Well, you know, I hope we're not going to war. I don't want us to be going to war. I don't want us to turn into another nation building exercise. So, yeah, I hope your son's just getting some TDY assignment and getting a bunch of per diem out of this. So I hope that's the case. And I hope he comes back in like a month or two and you guys go, wasn't that funny when we went to the brink of war? Instead of, oh my God, I helped vaporize half of Tehran. Or, oh my God, I helped drop the bunker busters on the Fordow nuclear reactors. I agree. I hope he's safe. I know he'll be safe. Yeah. Hope our servicemen are safe out there, even though they may have to go put some foot to ass. So, have you ever asked, was that a hard R? No, because the one time where we had to kept saying it, the guy had dropped a hard R. Like, it was on camera. It was on a video. Somebody filmed it, and he screamed nigger. Like, he hard R'd it. And you're like, all right, well, when you said that, sir, what did you mean by that? Are you racist, sir? Do you call every black person the N-word? And yeah. So, but yeah, guys, if you didn't know, things are getting interesting. Things are getting interesting out there. We'll touch on this real quick. Let's see here. I'm bringing up the pictures of Prince Sultan Air Base. Basically, like, everything is withdrawing. Strategic assets the Navy's pulled out of Bahrain and Qatar. The Air Force is withdrawing from Qatar. Everything's withdrawing and moving around. And this chat right here is... Oh, this is not a good quality one. Hold on. This is a good quality one right here. Hold on. This is Prince Sultan Air Base in Saudi Arabia, in the kingdom. That tarmac is loaded down. Those are all planes. Those are all fighter planes, chat. Okay? These are B-52s. That's a B-52. That's a C-130, 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 C-130. B-52s. Like, that's a lot of concentrated firepower right there. And these are all fighter planes right here. And then there's fighter planes in here. And this is out in the middle of the Saudi desert. And then these are also probably being used by aircraft. But there's a lot of firepower rolling out there. There's a lot of firepower out there right now. That is not a joke. That is not a joke at all. And this is because you can use the satellites to see what's going on. You can pay for footage, and people are paying because they are counting the airplanes at Diego Garcia. So it's, yeah, we don't know. We don't know. But yes, out of the Whitman Air Force Base, all of the B-2s appear to have left the country. Everything that's operational is on the way to Diego Garcia or is going to Diego Garcia. Is already there. And if you guys didn't understand what they're being used for, what they're needed for, this is what they're going after. This is what they're going after. This is where Iran stores all their fissile material. This is the Fordow fuel enrichment plant. It's in the side of the building. It's in the side of the mountain. If you guys have never seen these before, those are all entrances into the mountain. That's a power facility here. That's built into the mountain, but it's built deep in the mountain. That's where a lot of their fissile material is. Their enriched uranium, if they have any. And there's two ways you can do this. You can drop a big old bomb. You could drop a big bomb on it. Or you could send in commando teams. Now, the Israelis probably do have commando units that have been training for this operation for decades. But I'm sure that they're asking the Americans to drop the massive ordnance penetrators because the Israelis don't want to lose all their fucking men. So, yeah, Ethan Klein did this. Angela says you're outnumbered. What happened? What is the gap just as Ukraine from Putin and we're just throwing them away? I don't know about that. So, yeah, Tinker Air Force Base is sending all the tankers. Everything is going, guys. Much of 40 tankers left the United States already. Most of the U.S. tanker fleet is either doing a NATO exercise over in Europe or is supporting, you could take 4 fighter planes with a tanker and transport them from, here across the Atlantic to somewhere in, Africa, Europe, or Central Asia. So they fly along and they just keep refueling every 30 minutes. Yeah, it's getting interesting, guys. It's getting interesting. Marlene says the mother of all bombs. No, that is a separate item. The Moab is not what you'd want to drop. There's actually 2. You're thinking of the Moab. What you want to drop instead is this. The MOP. The massive ordnance penetrator. This is the This is Le Bunker Buster. This is the biggest bunker buster we have. It's meant to penetrate into the ground and then detonate. And the way you drop these, you drop like the B2 can carry 2 of them. It drops one, and then it waits a couple of seconds, it waits a little bit, and it drops the other one. And the first one goes in, burrows into the ground, boom, blows much of the crap out of the way. The second one burrows deeper and should hit the target. They may have to do a couple more, but that is a very different weapon than the Moab. Very different weapon. So, yes, Fort Howe is likely 20 stories underground. The only other option is you detonate a nuclear weapon, and a nuclear weapon will penetrate that deep. So. Roscoe says hello. Egregious Darkly says, why would we need them to land? This is a posturing. I mean, they literally get refueled in the air in aircraft carriers. Well, you could only fly in a fighter plane for 10, 12 hours before it becomes dangerous and uncomfortable and pilot workloads become problematic. So, no, they're all going to Saudi Arabia. So, we don't know how much it'll penetrate. We have ideas. But we don't know for sure. Some of that's classified. Yes, this can go about 90 feet into the ground. We think that's what it does. 90 to 100 feet into the ground. So, we don't know for sure. So, it's really easy math to convert. Well, we think we know what it is. But yes, you have to double tap to make sure you get it. So, we'll find out, chat. There might be a thing there. But anyway, guys, we're going to wrap this up. This is about time. And we are going to get started on Ethan Klein and his lawsuits against Hassan and his toolboxes going forward. And we're going to do that here in a minute. So we'll take care of it. In the meantime, chat, I'll see you guys in a little while. And remember, guys, until next time, just because you did it does not mean you're guilty. And more importantly, suffer. Suffer if you want to do discrimination, because everybody's in trouble. So take care, guys, and I will see you later in a couple of minutes, actually.
blacksmithing and models of planes, esoteric works and even some trains. Much merriment had while drinking White Claws, tips on hunting and even talking the law. Whatever you do, just don't talk to cops, even when they nab you on illegal stops. Just 'cause you did it doesn't mean you're guilty, but please talk to a local attorney. Was that the fat guy